Good afternoon, everybody, and welcome to today's webinar about your rights at work, particularly in this coronavirus pandemic that we are all living through at the moment. I'm Anna from the TEC, and I'm joined today by Sian Clarke, who is an employment rights solicitor at Slater and Gordon. I'll be passing over to her shortly. Just a couple of housekeeping issues. So you will have seen that we have live captions available for this webinar. There's a green button underneath the screen. If you click that and we open it, the captions will open in a new window. You must make sure that if you follow the captions that you close this window that you're in now, otherwise you'll get an echo. On the right-hand side of the screen, there's a panel where you can chat to each other, introduce yourselves, and share tips and ideas. And Sian will be trying to get to as many questions that you're posting as she can today after her first bit of the presentation. She's already looked at some of your questions and is going to include answers to those in what she says. But if we don't get to every question, please don't worry, because we will use your questions to inform any advice that we publish or anything we send out to you in any resources. So without further ado, I'm going to hand over to Sian now to get us going with some information about your rights at work.
Hi, Anna. That's lovely. Thanks for the introduction. As Anna has already told you, my name is Sian. I'm one of the employment lawyers at the Slater and Gordon Cardiff team. And I'm really grateful to be asked to come and talk to you this afternoon in respect to sort of the COVID matters and going back to work and the issues that are rising in relation to going back to work. I've had some of the questions beforehand, and that's been really helpful because there's a lot of sort of key issues that seem to be recurring. So I'll be sort of going through the answers in respect of those questions, and obviously Anna will be sort of bringing in any other pertinent issues that get flagged up. If I turn away, I'm really sorry, but I'm just looking down at my notes, and you know, I'm really sort of keeping abreast of everything. So firstly, obviously, as we know, in England, the government advice at present is still to work from home where possible. But where that isn't possible, the government is encouraging workers to return to work if they can do safely. In Wales, the position remains stay at home, and the First Minister gave a review on the 8th of May, and we know that that's going to be reviewed again in about a week's time. I think it's every 21 days they have to review. I think I heard on the news at lunchtime, Nicola Sturgeon has made some changes, and there's been a relaxation, or there is one coming in Scotland, but I can't give you sort of any firm details, as I just very sort of briefly heard that at lunchtime. So we know that the position for employers, employees, and the unions is very difficult at present. There's a very fine balance between protecting public health and safeguarding the economy. As we've said, we've got lots of questions, many common themes and scenarios that are raising concerns for people. So hopefully the issues coming up from the questions you've submitted will go some way to addressing your concerns. But what I would say is that it's generic advice. Obviously, some of the questions raise a particular scenario or what's going on in a particular work environment. But if you are in a position where you feel you need specific legal advice tailored to your particular matter, then obviously we would say what we always would do is speak to your reps first, and then if the matter needs to, it would be sort of referred in the usual way. But before taking any action, then we would always advise you to get legal advice pertinent to your particular matter. So if we can go to the first question we've had. And if I just read out the question so you can get an idea of sort of what it involves. This question states, what is the law regarding teachers who are being asked to return to work if they are at risk on the vulnerable list? Should head teachers insist on teachers getting a letter from their GP? Will this infringe on privacy and data? And teachers are worried that this may be used in other ways. What I would say is that this is sort of twofold, really. And I would also say that this question applies to all employees, not just teachers. And so there's information in there for all different sectors. And the first part of the question is, can an employer collect information from employees relating to COVID-19? And I would say that the short answer is yes. If it is necessary and relevant to do so, if there's a lawful basis under data protection laws. But employers must take care to keep data protection requirements in mind when considering whether and/or how to collect information and process that. So in an effort to manage the impact of the pandemic and in order to safeguard employees in schools, it would be safeguarding children as well. And then in other sectors, retail, protecting members of the public who are going to be in stores, etc. There is sort of a need sometimes. Employers may decide that they need to collect information from employees and employees' household members, which wouldn't ordinarily be information that they would be requiring or entitled to. This data is obviously going to be personal data, and it will be special category personal data, and the employer must comply with GDPR and the Data Protection Act, and it has to be that there is a legitimate interest. So in respect of the second part of the question, if an extremely vulnerable person wants to continue to shield at home, and that's either because of government advice or because there's no vaccine, it's likely that any insistence that they must return to work is going to lead to a potential claim under health and safety legislation, discrimination legislation. If an employee is an extremely clinical vulnerable, is deemed to be clinically vulnerable, then returning to the workplace may involve contact with a carrier of COVID. It's going to put them in danger of being infected, and so they're going to experience the effects more severely than others. If they refuse to come to work, if they have a belief that they're all, they have a reasonable belief that they're going to be in serious and imminent danger, then they're going to have certain protections, and we'll come on to that sort of shortly. They could also have potentially a disability discrimination claim. They're not going into work because of a reason linked to their disability. If they then are subjected to a detriment at their employer's insistence that they go in, then obviously there's potential there under the equality legislation for a discrimination claim. So the next question, that also relates to sort of an education background. And this is one that, again, really good question, because it involves a change in your sort of potentially a change in your terms and conditions. Lots of employers at the moment are going to be saying, okay, you can come back in, but we can't work in the same way that we did previously. And we might have to have flexible working. We might have to have different hours where we come in, staggered starts. We might have to work in different ways. And so this person has asked, to what extent can their employer ask them to work flexibly? So the background here is that the college is following a strict guidelines for individual risk assessment, social distancing, and other measures for September. And employees have been told that they will be moving to a flexible blended structure. To what extent can the college enforce us to work flexibly? Will our contracts or will they have to change the terms and conditions? So firstly, can your employer either reduce or extend your working hours, make various changes? Then obviously, yes, with the consent of the employee, which may be express consent, meaning that there's been a specific discussion and it's been agreed either orally or verbally, or there is implied consent, where the parties believe that consent has been given, although there hasn't been anything specifically written down. If there's no express term in the contract allowing for any sort of change in working hours, working days, then such a change would amount to variation of the contract. Now, some contracts of employment will have a wide variation clause, but these are unlikely to be interpreted to allow such a fundamental change. So if you are in the sort of education sector and you're now being asked to work through what would be summer holidays in order to gain back time, that would be a really fundamental change. And so it's likely that that is going to involve a change to contract. There's nothing to stop a person agreeing to a change if it's on a limited basis. So the employer could make the agreement that changes will come into place conditional on the happening of an event. So for example, you might agree a new type of blended working pattern as long as official government guidance recommends social distancing. And when that guidance expires, the contract reverts back to the previous one. You have to agree that the change or the alteration will be purely for a fixed period of time, and it has to be sort of, there will be regular reviews in relation to as and when these changes are still required. So question 3. This is a situation which I would imagine is sort of causing a lot of people difficulty. What can a person do if a company asks them to return to work, but the individual doesn't feel safe to return to work? The individual may be a vulnerable person themselves, or they live with somebody who would be classed as vulnerable. Are you entitled to ask to see the risk assessment the company has carried out? So again, this question, really useful question because it touches on a number of issues. I would say in relation to sort of part 1 of the question about whether or not you feel sort of safe to return to work, if an employee wants to shield at home because he lives with a vulnerable or extremely clinical vulnerable person, must an employer permit it? An employer may need to allow this in the short term to avoid having a claim brought against them under the health and safety legislation. You can't be dismissed from your employment if you feel there is a serious and imminent danger. An employee may say that in order to avoid danger to another person who is shielding in their household, they need to avoid travelling to a workplace or being in the workplace. And so employers will need to comply with their health and safety obligations and conduct risk assessment. And there would have to be, in this case, sort of consideration in conjunction with the employee in particular. Obviously, there will be a generic risk assessment. There will be new risk assessments brought in respect of the government guidance that's in place at the moment. But where you have a particular individual in these circumstances, I think that there would have to be a sort of a personal risk assessment, and consideration would have to be given to the extent of the danger and whether or not the employee could take other steps to avert it. I know that some employers have suggested, well, you're a married couple, if it's your child who's got, is the extremely clinical, vulnerable person, then one parent will isolate themselves so they can go out to work. So employers are trying to sort of get around the situation here, but I think risk assessment, the risk assessment would have to be sort of a detailed personal risk assessment to this particular circumstance. If an employee is...
Sian, can I just come in here as well, because something has been raised that relates exactly to what you're just saying about a risk assessment, as well as being generic. It has to you can also have a sip of water while I ask the next question. The risk assessment is generic, but also it does have to consider an individual's personal circumstance. Can this individual's personal circumstance include the journey to work? Does that need to be included when considering whether work is safe? Because the employer could do everything that they need to do in the workplace, but the commute is the problem. And is there any regulations or case law on that? I think this might be particularly the case in big cities when the only way to get to work is public transport.
Yeah, in relation to, because this is covered by Section 44 of the Employment Rights Act, and that is where you believe there to be, you have a reasonable belief that there is a serious and imminent danger. That can relate to the workplace itself, or the commute, how you get to work, or it can relate to somebody else who is in work standing next to you. It doesn't have to be the sort of physical environment that you're in work. And so if you are in a situation where you are having to commute to work and you believe that that is putting you in serious and imminent danger, you're somebody who is deemed to be vulnerable. If you contract the virus, it will have more severe impact on you. Then is your employer then required to make other arrangements in a risk assessment? Would they have to look at whether or not they send a taxi for you every day? Would they have to make sure that they are providing you with masks, gloves, hand sanitizer for you to use on your journey into work if you do have to go on public transport? And so that's sort of a really good point to raise, because sometimes people will think, well, whilst I'm okay in the workplace, my employer is making sure everybody stays 2 meters apart, I have to go through a really sort of, an hour-long commute. I have to sit on a tram with I don't know how many other people, and so it's the commute to work. And I'm not sure if employers will sort of understand that and take that on board, but if anybody is having an issue, then they are protected on their commute as well.
Yeah, thanks, Sian. That is really useful. And yeah, sorry, I interrupted your flow there, but I thought it was a good
it's
bring
really,
that in.
It's really good, because I think it's something that's going to affect so many people.
Mm-hmm.
Loads. If you're working in city centre, if your place of work is in somewhere where public transport doesn't go to, there's so many people who are going to have to be in that situation, and it's a really sort of key thing. Should I go in? Am I going to be putting myself at risk?
Absolutely. Thanks.
So obviously, if an employee is subjected to any detriment, or if they're dismissed because they refuse to return to work, then they do have a claim that they can bring for automatic and fair dismissal at the employment tribunal, or if they're told, no, you can't take any time off, or we're not going to furlough you, you can take your own annual leave. If you're subjected to a detriment in that way because you believe that there is this serious and imminent danger, then you'll have a claim because of a detriment. So there's a question now in relation to reasonable adjustments, and this is something that I hear quite a lot happening, in that there's always been a bit of a belief that working from home is a bit, you get the phrase shirking from home, and people don't believe that you can be productive when you're working from home. Now, we've had a situation where we've all, a lot of us, if we can, have been, forced to work from home, and there hasn't been any other alternative for our employers. And in a lot of cases now, it will be shown that working from home is perfectly feasible and there isn't an issue with it. Now, you could have had somebody who, previous to all of this, before the pandemic, had been asking for reasonable adjustments, had been asking if they could work from home. Their employer has said, no, you can't, we don't have a working from home policy. And they've now proved that they can. The question is, are we able to then fight for the member and make sure that this continues? So what I would say is, pandemic or not, obviously the Equality Act is there, the legislation is there. If you feel that somebody is being discriminated against, reasonable adjustments aren't being made, then you can always bring a claim. But in the current situation, if an employer is not engaging in discussions regarding reasonable adjustments, and if the employee meets the legal definition of a disabled person, then they would have a discrimination claim. And on a practical note, one of the positives that's come out of this situation, if you can think of any positives, is that it's been demonstrated, for example, in my own organisation, we're now all working from home, and I think that there are moves afoot, if people want to going forward, that working from home will be allowed 2 or 3 days a week. There'll be a more flexible approach to it. So employers, should be using this opportunity to see what works in relation to working from home, and the fact that productivity hasn't really dropped to a massive low. People aren't all sitting around sunbathing in their gardens. They're all active, doing their work, and that they can be trusted. So hopefully this is helping to show that it's feasible, and people aren't automatically going to be, you know, out enjoying themselves, walking the dogs all day and things like that when they're working from home. So question 5, this again, this is something that is coming up a lot. This is sort of specifics in relation to what protections you have under Section 44 of the Employment Rights Act. And just to give you sort of a bit of a background to that, that is where you have protection from any detriment, including dismissal, if the principal reason for the detriment or the dismissal is because of a health and safety issue. So if an employee believes or maintains there's a serious and imminent danger, they don't go to work because of it, and they're sacked, they can bring a claim. But in order to bring a claim, you would, you know, to make sure you've got good merits to that claim, you have to be able to show that it's reasonable. Now, obviously, a global pandemic, I would say that is a reason. And it's reasonable to believe that we're in serious and imminent danger. We're told it, you know, 24/7 across the news. But it's important for the employee to refer to government advice. So look at what the advice is at the appropriate time. Each case will be looked at on its own circumstances. Obviously, if you've got an employee who's failed to carry out any risk assessment, doesn't adhere, you know, doesn't put in place any PPE, doesn't ensure that you've got social distancing, is not taking on board any concerns from employees, then in those cases, I do think that you would have a really strong case to argument that there's a serious, you know, an imminent danger. Practical tips for an employee, I would say, if you're really concerned about going into work, the first thing to do, I would say, is check government advice. What's it saying? And we know now that there are sort of specific advice in relation to different sectors. I think there's 8 different sort of government advice, sort of ranging from, you know, all different types of working environments. So check the latest government advice. The second thing I would say is either work from home or has to be furloughed if working from home is not possible. So consider whether there are sort of any, you know, really, you know, is there serious and imminent danger? And this will depend on measures taken by the employer, sorry. Have they, as we said, if they carried out a risk assessment, can they provide you with a face mask, gloves, hand sanitizer? Is the employer giving enough information? Are there signs up everywhere to say that people should be going to wash their hands? When you go through doors, is there a hand sanitizer dispenser for somebody to sort of disinfect their hands straight away if you're having to touch common surfaces? Is there adequate cleaning of work? Is there testing for employees? So, you know, what step, if your employer is somebody who's got all those measures in place, you may struggle to say that there's a serious and imminent danger. But if you believe that there is, what I would say is seek legal advice. Communicate your concerns to your employer. Obviously, it's important that you've told them what the problem is to see whether or not they address it. And this is also a tactical point, because if you do end up bringing a claim, then you may be able to bring in a whistleblowing claim as well, because obviously you've drawn to their attention, you've made a protected disclosure that there is sort of a risk to the public and other workers. You could stay away from work, and then if you're disciplined, then obviously I would say, you know, follow your employer's internal grievance process and ultimately bring a claim to the employment tribunal for detriment or dismissal. Now, I know it's very easy to say bring a claim, and I think that there's a question within sort of the questions that Anna sent me, that somebody's referred to the fact that, well, what's the point in bringing a claim? There aren't any employment tribunals sitting at the moment, or you know, the awards that I get will be really low. But all I can say to that is that, you know, that we do have legal protections in place. They are there to ensure protections are in place for employees. And if you have made these protected disclosures, you're not only bringing an unfair dismissal claim where you just get what's called a basic and compensatory award for your losses, you potentially have uncapped losses, because the whistleblowing claim sort of adds to it. And so what I would say is, follow those steps, make sure you've brought it to your employer's attention, and make sure that you've done everything that you can do properly. You've followed the correct processes, and then it will strengthen your claim potentially. So this question, I would say, very, very relevant at the moment in view of what's happening in relation to, 1st of June is supposed to be teachers back in school with primary age. And so this question is where somebody is working in a special needs school. They have children attending that school who have underlying health conditions. The students themselves have physical and learning disabilities, and staff can't socially distance the recommended 2 metres due to the children's high care needs. How is this going to protect staff and students? And there's a second part to this question that deals with childcare, so we'll come on to that sort of shortly. But in relation to this question, I would say that we've touched on already the protections that there are for health and safety, but it's clear government guidance is telling us if social distancing can't be followed in full, then the sort of operations and activities should only be continued if they're necessary for the business to operate. It is clear that if a business can't maintain social distancing, then they're exposing their employees to more risk. There are sector-specific guidelines, and I believe these were issued back on the 11th of May. And so, you would have to look at the sector guidelines. I would imagine in a situation like this, then your sort of union is heavily involved in relation to the negotiations that are going on with whether or not the special needs school can reopen its doors. So I would just, engage with the union, again, voice your concerns, and make sure that, all government guidance is being adhered to. The second part of the question is that the person who sent us this question says that she has a child who's not likely to return to work until to return to school until September, because even if schools do go back in, we know I think it's only going to be year 6, which is top primary, and year 1, or whatever. So there's going to be a lot of children, up to the age of 12, 13, 14, who are going to be at home, we think, until September. You've got a lot of people who can't go back to work themselves. If you've got teenagers who can just look after themselves on Xbox all day, that's fine. But if you've got younger children, number one, they need homeschooling. You can't just leave them to their own devices, and you can't leave them on their own. So in respect of childcare issues, if you can't go back to work because you have children at home, schools are not opening, then the situation in non-pandemic times is that you are entitled to reasonable time off for dependence leave. There's no statutory obligation on employers to pay the employee for time off, and what is reasonable is not sort of recorded anywhere. It would all depend on the individual circumstance. An employee also has a separate entitlement to take unpaid parental leave for up to 18 weeks per child at any time until that child is aged 18. You have to give advance notice, and obviously there has to be sort of discussions with your employer. But the current situation is different. Obviously, the government recognises that we're in sort of unprecedented times. It's through, nobody's fault. It's not a situation where your childminder has become unwell and you're unable to send your child to a childminder. We're in a situation where all nurseries, childminding facilities, schools, everything is shut. And so during this period, the government's furlough scheme is supposed to kick in. And so an employer who is sort of, an employer will be permitted to place an employee on furlough if they're unable to work because they have caring responsibilities. And that would apply to caring responsibilities for your child, or if you've got caring responsibilities for another member of your household, you know, a close family member. If it is as a result of the COVID-19 pandemic, then you can be furloughed and receive up to 80% of your wages. So that sort of hopefully covers the issue in respect of childcare. What I would say, if this situation, you know, applies to anybody, then the key thing is to obviously keep engaged with your employer, keep them updated, regular discussions with them in relation to your own individual personal circumstances, and always sort of keep up to date with the government guidance. So this is question 7. Somebody has asked, can we expect a rewrite of safety regulations with immediate effect by the necessary officials of government, health and safety executive, trade union officers, particularly as there is a reference for return to work expectations? So obviously somebody here is saying, well, you know, what can we expect to be sort of put in place for us now? And, you know, I would say the very straightforward answer to that is, well, you've got a document called Working Safely During Coronavirus, first published on the 11th of May 2020, and now updated on the 19th of May 2020. And so that is sort of the government guidance in relations to you know, all the different sectors. You've also got government guidance and actions for education and childcare settings, again published on the 11th of May, updated on the 19th of May. And you've got government guidance for public transport operators, that sector. And so in terms of sort of, I would say that this is the most up-to-date guidance that's being put out there at the moment. So the next question, again, this is a very common theme that is coming up. It's relating to risk assessments. And this person is asking, do all staff need a risk assessment if they're on the vulnerable list, or somebody in their household is on the vulnerable list?
Sian, can I also add there something that's just come in as well about, while we're on the theme of risk assessments, somebody has asked if it's illegal to not share a risk assessment by the employer with employees.
Yeah, you are entitled to see your risk assessment. You know, it's something that is written to be adhered to for all people within the workplace. If you're an employee, you are entitled to see your employer's risk assessment in respect of what measures they are taking to protect people in the current situation. But that's sort of across the board in any event, even if you don't, you know, in non-pandemic times, as it were. But in this particular sort of scenario, you've this person, and this person sort of touches on this. What they're saying is, well, Section 44 of the Employment Rights Act and Section 8 of the sort of management regulations, all well and good, but what happens when somebody asserts those rights and gets the sack? You know, the ET is not running, sanctions are so weak, and there's no health and safety actions. Well, like we say, all staff need a risk assessment. And in the current sort of situation, in order to run a safe workplace during COVID, an employer has to do 3 things in particular. Number 1, they have to make a COVID-19 risk assessment tailored to its workplace and the dangers of COVID, which will include risk assessments carried out with vulnerable employees. And if there is a vulnerable employee, then obviously that person may need to have, in addition to sort of the generic work assessment, risk assessment, there may need to be input from occupational health, and you also may need input from that person's GP and medical information obtained. So secondly, the employer needs to set up a safe system of work identified by the risk assessment. And thirdly, it needs to make sure that that safe system is followed. So in relation to part 2 of the question, what happens if somebody asserts their rights? Then obviously we've touched on this already. Somebody with serious and justified concerns should be taking legal advice, go through the steps that we've identified, and if their contract of employment is terminated, then they can bring claims. Obviously, I can't say to you that those would be successful claims. Every case is dealt with on its own merits, but the employment tribunal is still there. It's still operating. We're issuing claims. We're having claims acknowledged. At the moment, we're not having hearings in person, but claims are progressing, and so your rights are still there. ACAS is still operating, and so conciliation is still possible. And in relation to sort of compensation, obviously the person that sent this question in highlights the fact that they believe that, well, sanctions are so low. What's the benefit in somebody, or what's to encourage somebody to issue a claim when you're going to get such a low award anyway? Well, in an unfair dismissal claim, because what would be an automatic unfair dismissal for health and safety issues, you would be entitled to your basic award, which is like, you can calculate that by looking at what you would get for your redundancy. It's the set formula. How many years have you worked there? What's your age? What's your gross weekly wage? You would get your compensatory award, which are your actual losses. So, from the date that you were dismissed onward to the date of the employment tribunal, you can sort of how long it will take you to get a new job. What are your losses in that period? And there's also an injury to feelings award if there's a whistleblowing claim, which, as we touched on already, that's uncapped. And so what I would say is it's always worth, if there is a situation where there's been a dismissal, or you're going to sort of, resign and claim constructive dismissal because of serious and imminent danger, then take legal advice and, look to see what potential claims you do have. And what I also would say is be very mindful of time limits. If you are raising concerns with your employer, and these are potentially what we would call protected disclosures, then you have a limited period of time to bring a claim. If you feel that you've made a protected disclosure, you then are subjected to some kind of detriment. All of a sudden you are facing, a capability issue, or there's a bit of misconduct that you're alleged to have been involved in. If you believe it's because you've raised those protected disclosures, then you have 3 months in which to bring sort of a claim from the date that you believe the detriment has happened. So question 9, again, really, really useful question. I think that we've touched on it already, but just reiterate very briefly. Can somebody say they are unable to come to work as they have no other way of getting to work other than using public transport? And as we've touched on, it doesn't have to be the workplace itself that gives rise to the danger believed to be serious and imminent. It could be the danger comes from other employees, or it could be the commute. You have to have a reasonable belief that your journey to work is putting you in serious and imminent danger. And so, if you were on a very packed tube, you could take photographs. You could, show that there are people sitting in very close proximity to you. There's no social distancing going on whatsoever. And that, this is putting you at really high risk in coming into work every day. And if your employer is not going to provide you with sort of any steps to overcome that, such as providing you with an alternative means of transport, maybe changing your hours so you're not having to go at a rush hour period of time, providing you with PPE that you can have while you are on public transport and in very close proximity to people. If your employer is not interested, or if they don't believe that that's their issue, it's nothing to do with them, it's only protection once you're in the workplace, then what I would say is, talk to your rep, take legal advice. So this sort of next question is really, again, really useful, really relevant, because it relates to the situation where employers now, obviously we know in England, lockdown itself has finished, and you are, being told by the government, if you can no longer work, or, if you can't do your job working from home, then you should be actively encouraged to come back into the workplace. In this particular circumstance, it seems that people can do their job working from home. I'm not sure what sector it is in, but this particular question, the person is asking or telling me that they have managers asking for sort of a rota system. So 2 people per team attend the office on a rota system, but the team have been working from home with no problems at all during the lockdown period. Some would need to use public transport to get there. And this person is asking, are we right that the arrangements don't fit in with current government guidance to continue to work from home where possible? Now, the various pieces of government guidance make clear that every reasonable effort should be made to work from home. If not, then you have to go into work, then social distancing and hygiene at work must be adhered to. In this particular situation, it does appear that working from home has been operational. And so I don't know whether or not it's a situation where maybe the employer is trying to test out whether or not they can get the office back up and running functionally. And that's why they're having this rota system, so that they know they've only got, limited amount of employees in the building on any one day. But really, I would say that we're not in that situation where, the government is still saying, whilst you can go back into work, if working from home isn't possible, we should still be encouraged to work from home if it is. And so in this particular case, I would sort of suggest that your employer is getting you to come in, and is not following government guidance. And so I would raise that with them. It's, as I say, it may be that the employer is trialing new ways to work, or it may be that on the days that people are expected to go in on this rota system, they may be doing work that you just can't do at home. I'm not sure. In some situations, you might have a system, a rota system in an office where people have to go in and check post and things like that. That can't be done from home, and so the employer may be getting around it in that way. But obviously, you need to explore what are the reasons that you're being asked to go in. If the work that you're doing when you are in the office is work that you would be doing from home, there's no additional tasks that have to be done and can only be done from the office, then you should be voicing your concerns. If working from home is feasible and it's been working, then are the company sort of acting in breach of the government guidance? Now, the next question is very, very short, very sort of brief, but again, a really sort of pertinent issue. And I know that a lot of employees will be quite worried at the moment. It's been something that people have done in the past. They have not disclosed their medical condition to their employer for fear of being sort of singled out. And so, I've dealt with cases in the past where somebody has sort of hidden the fact that they have a disability. I know nowadays when you apply for a job or you get a job, you have inductions, there's health questionnaires and things like that, but people still do sort of feel that if they disclose information about their medical condition, then next time there's a sort of restructure, anything like that, they're going to be sort of potentially the first out. Or if they disclose something about their medical condition and then get a cold or off sick for any reason, everybody's going to be, oh well, and you've got that kind of sort of belief. And so in this particular scenario, the person is asking, my employer is asking people if they're vulnerable or very vulnerable, and what's the catch here? Well, first of all, as we've said sort of right at the beginning, in the current circumstances, then it is, employers potentially do have a legitimate interest, a legitimate reason for asking details about a person's medical condition, because they have to, make sure they're not exposing other people within the workplace to risk. So if you, so a vulnerable person, is defined by the government as somebody to be either aged 70 or over, somebody with specified underlying health conditions, or somebody who is pregnant. And they're advised to be particularly stringent when following social distancing measures. And so they are people who, when we first sort of had, before lockdown, a couple of weeks before lockdown, people over the age of 70, they were being encouraged to stay at home. People who had sort of certain health conditions being encouraged to self-isolate. But they are not people who have been told to, shield completely. And so you have extremely vulnerable people who they are at a very high risk of developing a severe illness from the coronavirus because of their underlying health condition. And the government has written to all of those people, at the end of March, they've been advised to stay home for 12 weeks. So I suppose if you're being asked by your employer, or if you do have to disclose that information, then there is a specified list of what category you would fall into. And I think that you would know in any event if you were extremely vulnerable, because you would have been sent this sort of letter by government already. In terms of, what is the catch here, as we've said, it's personal data. It can only be used sort of in the context of your employer carrying out a risk assessment in respect of you and people within their workplace. And so if you did feel that there was any sort of dubious reason why you're being asked this information, or at a later point, information that you've disclosed because you've been sort of, required to as part of the sort of risk assessment process and the, return to work process, if you feel that that information is being used improperly, is being used by your employer in terms of, capability issues or anything like that, then you would potentially have a disability discrimination claim. So again, next question sort of follows on along the same theme, really. If social distancing can't be maintained, what is the position of staff who are in the high risk category? What's the position if you are not high risk? So you're not shielding, but you are vulnerable because you have an underlying health condition such as high blood pressure. Well, government guidance is clear. If social distancing can't be followed in full, then these operations or activities should only be continued if they're necessary for the business to operate. The employer has to ensure the safety of its workforce insofar as it's reasonably practicable. And that doesn't mean that if social distancing can't be maintained and it is necessary for the work to be taken, it's safe for the business to operate. So if the company, try and argue, well, we can't have social distancing, but we can't do our business without this particular sort of activity, or we have to reopen, then that's something that potentially, that should be challenged. If a business can't maintain social distancing, we know that they're exposing their employees to much more risk. If working from home isn't possible within, and this particular business, whatever it is not in one of the sectors that's been ordered to close. Obviously, if it's sort of, the hospitality industry, we know that they're closed in any event anyway. But you've got lots of sectors now that haven't been ordered to close. They're reopening, they're wanting staff to come back. And so, the employer will need to set up and implement systems under 3 headings to reduce the risk of virus transmission. So they have to sort of, identify the risk from infected people and the risk to vulnerable people. They have to identify the risk and look at the control of aerosol infection, which is a bit gross, but that's obviously coughing and breathing and spitting all over people. And then number 3 is the control of contact infection. So they have to look at, how many people are going to be touching this particular surface. What can they do to minimize that? Now, in relation to a vulnerable employee, if you're clinically vulnerable but not extremely vulnerable, and individuals can't work from home, you should be offered the safest available sort of role on site, enabling you to stay 2 meters away from others. So if you have to spend time within 2 meters of any other sort of person in the workplace, the business should carefully assess whether or not this involves an acceptable level of risk. Now, you could be in a situation where you are a pregnant person, you don't have any underlying health conditions, but being pregnant is sort of, is deemed one of the vulnerable categories. And in that situation, we know the same as non-pandemic times, somebody is entitled to be sort of suspended on full pay in those situations if the employer can't provide them with a safe place of work. And that would be something sort of worth raising. God, I can't speak now. But if you are in a situation where you feel, because of your underlying health condition, you are somebody who's vulnerable, the workplace can't offer you social distance, they just can't put these measures in place, then you should be having these discussions with your employer. Are there any alternative roles that you can do? Can you work from home? Can you be put on furlough? Because, you have these protections and your employer should be considering them. Sort of final question that has been given to me sort of beforehand, I think, yes, it is again touched on something that we've already raised, but just to sort of reiterate, can you be made to return to work following a furlough situation if you have a young child that you need to look after for part of the week? In this particular case, this person is telling me that her husband works shifts, and I'm also type 1 diabetic. I'm really confused. Well, I think, first of all, the guidance that has been given out by the government has really confused everybody. Obviously, the statement that the Prime Minister made, I think, was it a week last Sunday? So, on the Monday, well, on the Sunday night, the Monday morning, nobody really sort of knew what was going on. It was, really confusing for everybody. So I don't think that you're alone there. But to sort of answer the points that you've raised in your question, obviously we've broached on the fact that there is dependence leave, but because of the current situation, I would argue that you're entitled to remain on furlough while you have childcare issues, and so you can't be made to return. We know that the furlough process has been extended. Originally, I think it was going to be sort of till the end of June, but we know now it's extending. I would, imagine if some schools are to be opening on a limited basis in June, we hopefully by September, all schools, well, we just don't know what is going to happen, but that is the plan, that it would coincide with people coming off furlough at that point in time. But at the moment, I don't think that you should be concerned about sort of risk to your job or any detriment, because the government has this guidance in place. You have childcare issues, then the furlough scheme can apply to you. In respect of the sort of other point, you're type 1 diabetic. Obviously, you're not in the shielding list for clinically extremely vulnerable people, because you can look at that. There's government guidance on that, and it lists the conditions. And I'm sure everybody's sort of had a look at that if it's something relevant to them. But just as a point of reference, it is there, and you can see what conditions fall into which category. But if you're type 1 diabetic, whilst you're not extremely clinically vulnerable, you are still considered to be clinically vulnerable. So whilst you're not advised to shield, you will need, a risk assessment that is individual to you. And again, as we've already broached on, the employer could also need the input from occupational health or medical guidance from your own GP. So, those are hopefully those sort of points that we've gone through, whilst they may be sort of individual to people's workplaces. Like at the beginning, there were quite a few questions in relation to teachers, colleges, etc. I think that generically the situations apply whatever your workplace is. So I hope that there's been some useful information in there. But again, what I would say is it's not sort of legal advice that I can say, take away, go and rely on it, issue your claim today. If you are in that position and you feel that there is really serious and imminent danger, health and safety is not being adhered to in your workplace, then please seek legal advice about what to do.
Thank you so much, Sian. I think before we started this session, I knew we would be inundated with people's questions. And in fact, we have had a record-breaking number of questions posted. We've had 81, and I knew there was no way we'd be able to get to them all because, it's an incredible amount of questions. What I'm wondering is whether, we will certainly at the TUC take these questions. We will use them to inform content that we are publishing and, use it to develop guidance and resources for you. But perhaps we can arrange for you to come back at a future webinar in a few weeks, Sian, and maybe answer some more, because I think we've covered a huge number of subjects here, but I'm just looking at the questions that have come in, all 81 of them. There are other situations that people have questions about. So thank you again. I think it's been invaluable. And I don't know whether you can see the chat, Sian, but it's sort of going a bit crazy with people saying thank you. So I think everybody has found it really, really helpful too. And already like an hour has flown by and we've covered so much. So unless you've got any final words.
No, just to say thank you to you, Anna. It's really I enjoy doing this. Obviously it's an ever evolving situation, and so I would imagine within the next couple of weeks there'll be sort of different concerns that people have, and so always happy to come back and share whatever insights we can.
That is incredible, Sian. Thank you. Yes, so for the people who are asking, can you come and do another one? So we will, you and I will speak and we'll arrange that. So thank you, everybody, for tuning in. You've been great as usual. And stay safe, everyone, and we'll see you again soon. Bye-bye.
Thanks. Bye.